Hey there, I'm estate planning attorney Paul Rabelais, and in this video, we are going to address powerful provisions that should be in a power of attorney. So most people perceive estate planning as what happens when I die. But an important part of estate planning is the lifetime planning concept of using a power of attorney to have the right people act for you during your lifetime under certain circumstances. A power of attorney is accepted in all 50 states, but rules and requirements vary by state. So what is a power of attorney? A power of attorney gives one or more people, we'll call this person the agent, but you might also see them referred to as attorney in fact. A power of attorney gives this agent the power to act on your behalf. So what kinds of powers should you give your agent in your power of attorney? Well, because different rules apply in different states, it's a good idea to expressly include the powers that your agent should have, since you might move to another state, or your agent lives in another state, or your power of attorney needs to be used in a state other than your current state of domicile. The following are 5 powers that you may want to expressly provide in your power of attorney. Number 1, the power to make gifts. We have no idea what future income tax, capital gains tax, or gift and estate tax rules will look like. When you become incapacitated and, quite frankly, near death, it may make sense for your agent to be able to make gifts from your estate to your children or to your descendants in order to remove assets from your estate to avoid perhaps a 40 or 50% federal estate tax or a state estate or inheritance tax. Perhaps your power of attorney should expressly give your agent the authority to make gifts that are eligible for the annual gift tax exclusion, currently $15,000. Number 2, banking transactions. Banks have a reputation for being fickle when it comes to being presented with a power of attorney. The banks do not want to be on the hook for inappropriately honoring a power of attorney. The bank's attorney may feel more at ease if you specifically and expressly grant your agent the authority to deposit monies, write checks, and handle other routine banking transactions. Number 3, stock and bond transactions. And if you think banks get a little nervous when presented with a power of attorney, then you should see how the brokerage firms and stock transfer agents react when someone presents a power of attorney and wants to transact the $10 million investment account. So not only should your power of attorney authorize your agent to handle stock and bond transactions, but you should also look into whether the brokerage firm has their own power of attorney that they would expect you to sign. Number 4, purchase and sell real estate. And if you think banks and brokerage firms get a little testy when presented with a power of attorney, you may not have ever dealt with a real estate title attorney who was presented with, just prior to closing, a power of attorney. Your power of attorney should expressly grant your agent the authority to transact real estate on your behalf. And to further ensure that your designated loved one will be able to transact your real estate and your stocks and bonds on your behalf, some people opt to transfer these assets to a revocable living trust where you designate yourself as the initial trustee, but you name your designated and trusted loved one, the same person who is designated as your agent on your power of attorney, as the successor trustee of your trust. And number 5, digital assets. If your power of attorney is several years old, or maybe if it's several days old, you may not have given your agent the authority to access your digital property and digital accounts. Make sure your power of attorney expressly and specifically allows your agent to access your digital assets, including your online accounts and electronic communications. And if your online account provider allows you to activate an account setting that directs the online account provider to release digital property to your agent or legal representatives, you should activate that setting. In addition, you should strongly consider making your power of attorney durable, which means it stays effective or durable throughout your incapacity, which is when it will be needed. And you should also consider making sure that any new power of attorney that you execute revokes any prior power of attorney that you may have previously executed. And finally, be careful about who you give power of attorney to. There is quite a bit of power of attorney abuse going on out there. Make sure you name as both your primary agent and your alternate agent someone you can trust. Now, do me a favor and make sure you hit the like button. If you have any comments about some of your prior power of attorney history, feel free to share that in the comments below. We love to see the comments. And then make sure you subscribe to my channel. That'll help me out, and YouTube will tell more people to watch my channel. Okay, we'll see you next time.